Law and Talker. Hello and welcome back to another episode of the Law and Talker podcast. Today another English episode because we will have a look and we will take or perform a comparison between data protection regulations in Europe and in the US, and we will have a look in each state or union, and we will answer the question what data protection regulations are in place, how they are executed, and how well the data of citizens is protected under the certain or specific regulations in each union or state. Therefore, we will first take a look at the European laws for data protection, then we'll have a look into the US, and we'll answer the question whether the US has any or has only specific or only state and not federal laws for data protection regulations. And we will then have a comparison between the protection levels in the US and in Europe, and then we will come to a specific conclusion, I hope at least. I came to this topic through an article in the New York Times where there was an explanation or a report about the video cameras and surveillance cameras being placed in New York City, and how basically the NYPD, the local police department, is able to view every camera and is able to perform a surveillance of the whole city through the cameras that are installed in New York City and are planned to be installed. And that I thought was very concerning, and I thought that would not be possible in Europe, at least not to this extent. And then I researched whether the US has a similar or quite a different approach to data protection. And as it turns out, the approach is very different. So we'll have a look and see what the differences are. But first, we will have to answer the question: what kind of protection level is executed in Europe? And therefore we will have to look at the General Data Protection Regulations, the GDPR, which is the main regulation for data protection in Europe, and it is in place since 2018, and as the EU states on their own website, this possibly or most likely the toughest privacy and security regulation in the world, it is based on certain principles which we will further examine, and then we will see how this compares to the approach that the United States of America are taking. The GDPR constitutes in Article 5 certain principles for processing personal data, and the GDPR applies to both private entities and to state entities in regard of the protection of personal data for a natural human being. So both companies, private companies, but also the state and governmental institutions are bound to these the following principles for protecting personal data for the citizens and their users, respectively. In Article 5, of the GDPR, it is stated that personal data must be processed lawfully. That is the principle of lawfulness, fairness, and transparency. Then personal data has to be processed on the basis of purpose limitation, which means that there can only be a certain purpose which has to be set in advance for processing data, and the data that is going to be processed after that can only be processed for this certain purpose and is limited to that purpose. So, for example, a company is not allowed to extend or to use the data for other purposes than the previously set purpose which is also most likely or hopefully yeah written down in the contract between, for example, a private company and a human being. Then the principle of data minimization applies in the EU. So for whatever purpose data is processed, it has to be the least amount of data that is necessary to fulfill the purpose that is set in advance. And it is not allowed, or companies or also the state is not allowed to basically collect more personal data than it needs to fulfill the certain purposes that are set. Data also has to be accurate, which means that users and human beings whose data are processed are able to or have the right to update their data to keep track of the data that is processed and to ensure that the data is up to date, that wrong data is to be deleted, and so on. So companies have to watch that and have to offer the users and their contractual partners the possibility to correct and to delete data that is incorrect or not needed anymore. Then there's the principle of storage limitation, which means that the data that is processed for a certain purpose only needs to be has to be stored in one selected place, and is not to be stored longer than needed or further extended than needed. So it is not allowed to, basically, if it is possible to store data in the EU, it is not allowed to export the data into the US or in other countries where it's not needed to be saved there. Next, there's also the principle of integrity and confidentiality, which means that data shall be processed in a manner that ensures appropriate security for personal data. So companies have to ensure certain protection mechanisms, and it has to be protected against unauthorized and unlawful processing. And also, a company has to establish protection mechanisms that prevent accidental loss, destruction, and damages to the data. And this is to be performed by technical and organizational measures. Finally, there's also the principle of accountability. The controller, which means the entity or person that is collecting the data, is responsible for all the principles stated in paragraph 1. So all the principles I just explained and listed. The controller is accountable for them, and if he or she or it is not complying to these principles, it may face suits for damage suits and so on. So these are the main principles of the GDPR, and furthermore, there's the principle of opting in and the principle of prohibition with the possibility for allowance. And that means that first, the opt-in principle means that users always have to give consent before their data is processed, and not the other way around. Their data is processed all the time, and they have to object to the processing. So it's the other way around. The opt-in principle means you have to always consent to each process of your own data. And then the principle of prohibition with the possibility of allowance means that it is in general prohibited for any organization, for a company, or for a state, for the state to process personal data, and only in certain situations, in certain predefined moments, it is allowed to, and under certain predefined conditions, it is allowed to process personal data of a human being. And these exemptions, you could say, are stated in the General Data Protection Regulations and in other regulatory forms that are already in place or are going to be in place in the future. For example, the Data Act or the Digital Services Act and the Digital Markets Act, which all constitute more specific, sometimes, regulations for data protection and for exemptions under which conditions possibly it is allowed to process personal data of a natural human being. All in all, we can conclude that the GDPR is very strict and very protection orientated. So it has basically the goal to keep the possibly most highest standard of data protection, and only in certain circumstances and under the practically controlled mechanism, it is allowed to process personal data for companies and for states, always under the condition that the person which data is processed has complete control over the process, and is always able to stop the processing of personal data, and thereby has complete ability to control their personal data and their personal belonging in the end, because data is treated as an essential part of one's own personality and one's own rights to control and to perform or decide on whether it is processed or not. So that's the principle in the EU, and now we have to have a look at the United States. And while researching this, I was very surprised what I found, because as it turns out, the United States don't really have at least a federal regulation for data protection. So in general, it is basically allowed for companies and for the state to collect as many and as much data as they want and as they are able to do. Only 5 states have, on a local state level, so-called privacy acts. That's California, Colorado, Connecticut, Virginia, and Ottawa. And in other states, there are some legislative processes that are undergoing for data protection laws. But basically, in these states, it is possible for companies and also for the state to collect as much data as they please. Only some federal laws apply for all states, obviously. And these are, for example, acts like the Health Insurance Portability and Accountability Act, which regulates the privacy for medical data. Then there's the Fair Credit Reporting Act, which covers information for credit reports. The Family Education Rights and Privacy Act, which is dealing with student education records and so on. So there are some very specific federal data protection laws, but there's nothing compared to the GDPR in the EU, where you have a broad general data protection law that protects the users and the natural human beings in general, and protects their personal data in general, and prevents unlawful, useless processing or in-transplant processing and unfair processing of personal data. And furthermore, and this is also a quite significant point, while these specific federal laws are in place, and while there are some states that have privacy protection laws, most of them are based on the principle of opt-out. So you have, as a citizen, you have to be very aware which data of you is possibly collected, and then for each processing you have to declare that you're not consenting to that processing and that you want to opt out of that data processing, and not like it is regulated in the EU, that you have to give consent and otherwise it is forbidden to process your data. So the whole basic principle is basically turned on its head in the United States, and we have a very, very different handling of personal data and the processing of personal data in the United States. So coming back to the example of New York City and their very advanced tracking and video surveillance systems, it is no surprise that this is A, possible, and B, executed in New York City, because there are basically no federal or state laws that prohibit the NYPD or the state or also companies for placing surveillance cameras wherever they want, and for saving the data that is collected through these cameras for as long as they want, and for using it however they want. And that is, in my point of view, quite a concerning diagnosis, because there's basically on that front no real protection for citizens regarding their personal data, and they are very, very vulnerable to basically unfair processing and probably immoral processing of their personal data, because it can be used and can be misused for a large amount of basically every imaginable kind of misuse for personal data that is possible, and that also regards their behavior, how they are moving, how they are have certain behavior mechanisms that they are acting out in their day-to-day life, and that is from a citizen who's living in the EU like I am, kind of a bizarre founding, because you would think that the United States, being such an advanced Western country, would have more human or personal orientated data protection laws, and also be very aware of the problems that are connected to having no protection for personal data use. But as it turns out, that's not the case, or it at least has not been the case, because, as I mentioned, there are in 5 states there are specific privacy acts, like the Virginia Consumer Data Protection Act, the California Consumer Privacy Act, and in many other states there is legislative process in ongoing that can result in similar privacy acts like we see in these 5 states, but that's not for certain. On the other hand, it has also to be mentioned that the US is turning its head to a more strict privacy regulations and more data protection orientated approach. because, as I mentioned, 5 states already have stricter regulations, and in general, there's the feeling for a need for stricter data protection regulations. And the New York Times listed or interviewed some experts on this matter in the US, and they all came to the conclusion that these privacy laws, as they are also in place already in these 5 states, can be a flaw for possibly a federal regulation and for other state laws. And this flaw has then furthermore consist of at least 4 basic principles, and they are orientated by, or they are led by, the principles that are set in the EU by the General Data Protection Regulations. And these 4 principles are also data collection and sharing rights, opt-in consent, data minimization, and non-discriminatory and non-data use discrimination. So the first point, data collection and sharing rights, is also a principle that is further advanced by the new regulation, the Digital Services Act in the EU, a law that will be in place possibly by the end of 2024. And in this law, it is regulated that a citizen has to be able to switch between different services, for example, WhatsApp and Telegram and so on, and to be able to transfer their data easily from one place to another, and so be able to switch between services easily and not be locked into one certain service, and therefore be vulnerable to certain developments that this specific service which they are possibly logged into are ongoing. And so if they are not longer consenting to the approach a certain service is establishing, they can easily switch. And that's what the Digital Services Act is trying to establish in their in the regulation. The opt-in consent, as I already mentioned, it's a basic principle in the General Data Protection Regulation, and it should be the principle for any data protection regulation that is taking itself seriously, because it basically gives the right and the control of the data to the citizen it belongs to, and not in the hands of the companies or the states that are processing the data. So the opt-in principle should be the basic flaw for any data protection regulation, which also applies to the principle of data minimization. So a company should not be able to collect more data than it really needs for a certain purpose that is, for example, set by a contract between a company and a citizen. And also, and that's very important, possibly also in the US, the non-discrimination and no data use discrimination. So a company cannot discriminate their users, for example, if they have a bad health record or so on. And that's also a very basic principle, I think, that should be established by any regulation that is trying to seriously protect the data of the citizens. Yeah, so all in all, the US and the EU are at the moment have very different approaches to data protection. There's a very strict data protection regulation in place in the EU in form of the GDPR, and there's a very low level protection mechanism in the US on the federal level, and only in certain states there are some privacy laws, but they are not at all as advanced as privacy laws are in the EU. And on the other hand, it has also to be said that the US is looking to advance its legislation on data protection. So although there might be some ground that the US can make up, it is possibly on the right way from stated by someone who is in favor of data protection. But you might have different views on that, so let me know if that's the case and we can have a discussion. But I think it is very important to have effectful data protection mechanisms in place, especially looking at the development of the world in the last years and the upcoming years. There will be no way around effective data protection. Otherwise, the rights of the citizens are in serious danger if they are not able to control their data that they share online, and that is online probably for the rest of their lives and for longer than that. So data protection is probably the key right for the upcoming years. Yeah, thanks for listening to this episode. I hope you found it interesting, and maybe you're also as surprised as I was when I learned that the US is very much not up to date regarding their data protection regulations. And yeah, let me know if you like the episode, and I'm happy if you tune in next week. Thanks so much for listening, and bye bye.